Good afternoon and welcome to Getting to Yes, Understanding and Applying SCA and DBA Price Adjustments. Thank you all for joining us. I am Nichole Atallah and I'm a partner at Polaro Mazza in the Labor and Employment Practice Group.
And I'm Sarah Nash. I'm an associate here in the Labor and Employment Practice Group.
Just to give you a little bit of background about Polaro Mazza, if you're not familiar, but we are a full-service law firm here in Washington, D.C. In addition to the Labor and Employment Practice Group, we have a corporate and government contracting practice, and a litigation practice group. So we are happy to be here with you today to talk a little bit more about price adjustments. Today we really want to talk about just a brief overview of the prevailing wage laws and wage determination so that you understand in the context in which we want to talk to you more about price adjustments. We also want to spend some time talking about what kinds of costs are recoverable under price adjustments and how you can calculate them. We do quite a bit of this type of work, and in our experience, there seems to be a lot of confusion around, what types of costs are recoverable depending on what kind of issue you have. And it's not the same for every particular situation, and we'll talk about some of those examples as we go through today. And then we want to learn about talk to you about what type of documentation that we've seen prove successful in expediting price adjustments so that, you're not, if you're a contractor, you have some limited control once that price adjustment request goes out the door, because of course you have to get an answer back from the contracting officer. But there are things that you can do to make that feel like a less monumental task for the government agency. And so we want to kind of discuss what you can do to expedite that process.
Okay, so Nichole mentioned we're going to go over some of the prevailing wage laws out there, and there's two of them, right? There's the Service Contract Act, which deals with service employees, and then there's the Davis-Bacon Act, which deals with construction. Let's start with Service Contract Act, kind of a brief overview. It was passed in 1965, and it has a requirement that certain contractors have to pay prevailing wages and fringe benefits to all their service employees. And it only applies to certain contracts. It applies to contracts in excess of $2,500 that are located in the United States and the District of Columbia. And it applies to contracts, the principal purpose of which is to provide services through the use of service employees. And there's a lot of general confusion around principal purpose often, and it's basically just a simple majority of contract requirements include the need for service employees. And this can either be in terms of dollars, greater than 50% dollars, or full-time employees. And one important thing to note is that DOL, who is sort of responsible for enforcing the SCA, doesn't always abide by this rule. Sometimes they have a lower threshold that they apply. It's not written down anywhere, but it's about 20%. So ultimately, it's the contracting officer's decision whether to put SCA in the contract, but it's good to know what you're getting into based on how much work you're doing with service employees.
We did have a question, just so you, as a kind of a housekeeping matter. Some of you submitted questions in advance, which is fantastic. So we're going to try to pepper those answers throughout the presentation today. But please feel free as we go along to ask questions as well, and we will get to them as quickly as we can, or we will take it offline. But one question that came in dealing with this particular slide is, there is a piece of the regulation that deals with waivers, and the Department of Labor can waive the requirement to put the SCA in the contract, even if all this stuff exists. And so the question is basically, how do you get a waiver, especially if you know that there aren't that many SCA service positions on your contract, right? And the answer is that you could go to the contracting officer and appeal to them to get a waiver from the Department of Labor. But it's not something that a contractor generally does. So that's what you have to kind of keep in mind. If as Sarah mentioned, if the contracting officer already decided to put it in and they're not willing to budge on that, then you're kind of stuck. It becomes a contractual term. We are going to talk about what a service employee is next. So let's go to the next slide because that came in as a question.
Perfect. Sets us up, tees us up nicely. Let's start with service employee. It's any person engaged in the performance of the contract who is performing services. And it's regardless of contractual relationship. It can be an independent contractor or an employee. And it's pretty much anyone who is not exempt under FLSA provisions. And those exemptions are the standard executive, administrative, or professional employees under the FLSA. So you're talking janitors, doormen, service industry folks who are performing on contracts. And it's not the people who are administering those contracts.
It could be food service workers. There's secretarial, general clerks. There are lots and lots and lots of those types of positions. And where we see the confusion is usually with the administrative folks because they start looking sometimes in that gray area of exempt. So that's kind of who a service employee is. And another question that just came in is, can a contract be SCA if most of the people are not full-time? And the answer is yes. It doesn't really matter if employees are full-time or part-time. If the majority of work on the contract is service work, that's really what controls. So you're not going to be able to get around it by, say, hiring all part-time staff. And to go back to kind of how many service folks have to be on a contract, we've heard from the Department of Labor that they'll use a 20% figure instead of like a 50% figure, meaning, 20% or more of the employees are service. But I've seen contracts where there are 5 people or fewer that are SCA. And it doesn't necessarily have to be, but a contracting officer has decided for whatever reason to include it. And once they include it, it becomes a contractual obligation. We're going to go into Davis-Bacon, but I think one thing that's important to note is that it is not uncommon for a contract to include both the Davis-Bacon Act and the Service Contract Act in a contract, particularly on IDIQ contracts. If your task orders don't break out which one applies, it essentially means that you have to decide. And that goes to what I like to think of in both SCA and DBA as the contracting officer's responsibilities and your responsibilities if you're a contractor. And the contracting office or the agency is responsible for getting the right SCA or DBA clauses in there, getting the right wage determination in there. And we'll talk about wage determinations in a second. And if you're a contractor, your job is to select which one applies. And we'll talk about what Davis-Bacon applies to in a second so we can distinguish between the two. Sometimes it's hard to tell, but there are ways we can do it. And your job is to pay the right wages and fringe benefits, which means you have to classify employees correctly. And classifying is picking the right job classification. Are you a general clerk 1, 2, 3? Are you a painter? Are you a journeyman? What are you? And paying the right health and welfare or fringe benefits. So that's kind of what your job is. And it's hard when there's both an SCA and DBA clauses in there, but it can be done.
And we had a question about kind of how to determine whether an employee is exempt or non-exempt. And it's not just based on how much they're paid. There's 2 tests essentially. One is their method of payment, how much their salary is, and then the other is duties. So ultimately, if you have a very highly paid, in this example, graphic designer, that doesn't exempt them from coverage of the act. You still have to pay service contract wages and benefits. And
we get the question a lot, normally this position would be exempt and salaried, but I pay them by the hour. So does that mean they're still exempt? No, you lost your exemption. And the way that the SCA defines its rules is once you're non-exempt for whatever reason, then you're swept up under the SCA. So we work a lot with clients to develop kind of compensation plans and policies to try to meet the needs of you, where you might have sporadic workers that it's hard to pay a salary, and whether it makes sense to try to get them classified under an exemption, or whether it makes sense just to pay the SCA rates or to bid it at SCA rates. So these can be complicated questions. We spend, that question in of itself could take us an entire hour. So if you have questions about the Fair Labor Standards Act and exemptions and how to apply them, please let us know, and we'll walk through those exemptions in more detail so that we can give you better guidance about how to apply that and whether the SCA would apply.
So that's SCA, and very similar, but also very different is the Davis-Bacon Act. It's important to remember, even though these are both prevailing wage laws, they have different regulations and different requirements. Davis-Bacon Act, it was passed much earlier. It was the first of the Prevailing Wage Acts. It was passed in 1931, and it applies to contracts in excess of $2,000 as opposed to $2,500 under the SCA, which are covered by either the federal government. There's also actually District of Columbia can be a party. And they apply to construction, alteration, or repair. This pretty much includes what you would expect, but it also has painting and decorating of public buildings included. And it requires that you pay prevailing wage rates to mechanics or laborers on those projects. Remember that it's not just construction, it is alteration. Nichole spoke to the kind of overlap that you might see between SCA and DBA. This is where you might see it with, for example, a painter. Is a painter intimately in charge of alterations and remodeling, or are they just sort of painting on a new fresh coat and they're more service employees? Often this is where the contracting officer might include both Davis-Bacon and service contract into the contract and just hope that the contractor figures it out.
And we've seen that on excavation work as well, excavation work, repair work, where there's some crossover, or some MATOC contracts, you see it sometimes as well. And, as one person has pointed out, that in trying to make some of these determinations, when the contracting officer might put both in, you are taking a fair amount of risk. And the question was, shouldn't we ask the KO to make the determination of what applies to each task order? And that would be nice if they'll do it, but they're not obligated to do it. So you will see some task orders where on a Q&A or something like that, a contracting officer might answer your question, but they're not always obligated to make that determination for you. They're obligated to put kind of what I call the right stuff, the wage determinations and the clauses in there. And then it's your job to figure out how you're going to perform the work. So it really is fact specific to the contract and whether that contracting officer is willing to take some amount of risk in putting things in the contract. I've seen contracts where there's no information given at all. And I just had a situation this week where the contracting office put not only the SCA in, but said this position's exempt, this position's non-exempt, these positions are SCA, and these are the LCATs. These are the labor categories we want you to use under SCA. That's very, very detailed, and I would say is on the rare side. But the contracting officer took on that risk in that particular case.
And under the DBA, it's a lot more clearer who's a laborer or who's a mechanic, who's covered, because these are physical manual positions, manual labor. And because of the unionized nature of the trade, a lot of these have very clear categories. Like you're a plumber, you're an electrician. So it's not quite as complicated as the SCA. Apprentices and trainees and helpers are included, but you have to categorize them in the right way. So that's something to remember. Also remember that there's a lot of Davis-Bacon related acts out there that are issued by states. Not every state has them, but many do, and so those extra rules or laws will also apply. So the whole reason we're here is to talk about price adjustments. And the reason that we need price adjustments is because the nature of wage determinations makes it such that wage determinations are fluid and they change throughout the year, and they can really change the value of a contract. So the Department of Labor issues SCA and DBA wage determinations, which establish minimum wages and fringe benefits that you have to pay to employees performing work on your contracts. And the DOL, from time to time, will revise these wage determinations, and they reflect current prevailing wage rates, because since they're prevailing wages, they're changing regularly enough. And the most current wage determination ideally should be incorporated into whatever contract you have. And so the nice thing about this topic is that ultimately it's the contract that controls. So it's good to know what the laws are, but it's better to just know what your contract says, because if you read your contract carefully, you're going to see exactly what's covered, and that can just guide how you classify people.
And it might not happen right away. So you might know that DOL has issued a set of wage determinations. Under Davis-Bacon, they're usually done at the time of contract, whereas SCA, they might be updated annually or periodically, or you might see long periods of time where they're not updated. But even when DOL issues new wage determinations, or new wage determination applies, it won't get into your contract generally until the next option, and no less than every 2 years. That's the regulation. So your contracting office isn't necessarily required to put in a new wage determination right after one is issued. There are timeliness kind of issues there. Usually it's at the option years. And we're going to talk we've gotten quite a few questions about this, but we're going to talk through the wage determination in the next few slides, so hang in there with me, and then I'll talk to you about some of the issues you're raising with respect to which wage determination should apply to your contract or your subcontract.
And it's important to remember that there are different kinds of wage determinations. The most common ones that you'll see is the prevailing wage determination, which it's issued by the DOL regularly, every 2 years or so. And they're based on surveys that they send out and determine what the prevailing wage rate is in your state or your locality. So that's the first kind, but you also have wage determinations that are based on collective bargaining agreements. So these are wages that have been negotiated between employers and their employees' collective bargaining representative. And the tricky thing about CBAs is if you bid onto a contract where there is a CBA in effect, ultimately that CBA's wages and fringe benefits become the prevailing wage that you have to pay to your employees. So sometimes you don't always have a copy of the CBA on hand before you make a bid, but ultimately the contracting officer should be able to incorporate those wages into the solicitation. And
it should be in your solicitation. So the CBA it's supposed to be the wage determination. Sometimes you'll see both a wage determination and a collective bargaining agreement. But if you see a solicitation with a CBA in it, pay close attention. If you're DBA, it might be that those wage rates are already in the applicable DBA wage determination, because a lot of the Davis-Bacon wage determinations are negotiated by the job. So they would already have some of the union rates in there. And that's to kind of level the playing field between the union folks and the non-union folks. So it's a little bit different in the Davis-Bacon land, but for SCA purposes, you would see that in the solicitation of the contract generally.
And whenever you have SCA or DBA contracts, there should be a price adjustment clause that's included in them that it references both the SCA and the DBA, or whichever applies to the contract, the price adjustment clauses that provide for a price adjustment when a new wage determination is incorporated into a contract. And it's not a discretionary thing. It is something that you are entitled to based on a change in the contract.
So before we move on, I'm going to I'm gonna go through just a couple of questions because we do have a lot of questions pertaining to contract incorporation. And sometimes we get into disagreements with contracting officers about which WD applies. And ultimately, this is why you never go out and get your own wage determination. There's a place online that you can go and you can get wage determinations, and you can kind of see which one you think should apply. But ultimately, as Sarah pointed out, this is a creature of contract. So you can kind of appeal to the contracting officer to include the one that you think should apply. But ultimately, if they disagree and they put in an old one, that's what governs. And the only agency or entity that can fix that is the Department of Labor. So if there were, say, a complaint to the Department of Labor, and the Department of Labor came in and looked at it and said, no, the 2017 wage determination should apply, not a 2015 wage determination, the DOL can make, per regulations, they can require that the agency change it and make it the new one, or whatever one the Department of Labor applies. Most contractors are not particularly anxious to call the DOL themselves. Usually it comes up in the context of an employee that calls or something like that. But generally, you'd be looking at things like when is the option year? Is there a new wage determination? Why wouldn't, frankly, the contracting office could just say, well, this is the one that's already been in there, or they don't understand the requirements. So if you can't work it out among yourselves, between the contracting office and yourself, a contractor, DOL is the only one that can force your hand or force anyone's hand, and sometimes that's challenging. But again, apply what's incorporated into your contract. I can't say that enough. If you happen to be a subcontractor, this just gets even harder. Technically speaking, when the prime gets a new wage determination, they're supposed to flow those down to the subcontractors. If they don't do it, you as a subcontractor are still only required to pay what's in the wage determination that's applicable to your contract. Okay, so if the DOL investigated, which we hope wouldn't happen, they would ultimately look to the prime contractor to make up that gap, because you are, your subcontract controls. The most that you could do as a subcontractor is go to the prime contractor and say, hey, has any new wage determination been issued on this thing? Because I was just wondering, it's been a long time, that kind of thing. So those are the kinds of things that it's a little bit of a challenge sometimes, because your employees are asking where that increase is that they know that all their pals are getting on a different contract, and you've got to maneuver that. Go ahead.
I was just going to add that it's not just a best practice. There can be really, and we'll discuss this in a little bit, there can be really bad consequences to paying more than what the contract requires, because it really impedes your ability to get a price adjustment. So you on your own deciding, I want to pay my employees this additional, 50 cents, $2, you're not necessarily going to be reimbursed if you do that voluntarily without it being in the contract.
And that goes to one of the questions that came in as well, is does the government have to update the WD? And if they don't, can we still get an adjustment? Well, you're not eligible for an adjustment until the contract changes or modifies. Remember, these are creatures of contract. So the key is, what is your obligation in that contract? And if your obligation in the contract never increases, regardless of whether the DOL put out a new WD, there would be no eligibility for a price adjustment under that clause. And that's what Sarah was alluding to there, that if you do it in advance, you could be in trouble. So let's move on a little bit. What are these SCA price adjustment clauses? Well, these are the most common one I see is 222-43, which is multiple year and option contracts. So the function of these are basically the same. It just depends on what kind of contract you have, right? So do you have a base plus 4 option contracts? That's going to be your -43, and not the 4-4. That because those contracts are so common, that's why we see them so often. As far as Davis-Bacon goes, these are your 3 Davis-Bacon clauses. Generally, we see the -32, the one that's in bold, However, there are other methods. Basically, the methods are negotiating in advance, what the costs are, or some sort of indexing under -3.1. But we see a lot of the -3.2s.
And that's because it's just the more complicated of the three. It's the one that actually requires calculation as opposed to just inserting a certain.
Exactly. So generally, you'll note if you looked closely at the last two slides that there was nothing that said cost reimbursable contracts. And that's because there is generally no price adjustment clause for cost reimbursable contracts, because the idea is that you would get your costs reimbursed, and there's a method to do that. So we just wanted to note that. Some under firm fixed price contracts, the only ways you can get a price adjustment, not necessarily an equitable adjustment, which is different, but a price adjustment under the SCA DBA, is through the changes clause or the applicable price adjustment clause. And so it's important to know which one of those applies and when you need to look at it. So what we like to say is, if the government never included a prevailing wage law or a wage determination at all, and DOL comes in and requests or requires back pay for the employees, because then you're saying, what? Nichole and Sarah told me these things were creatures of contract. Mm-hmm. I shouldn't be on the hook for this because the agency didn't include all the stuff that they were supposed to include. But as I alluded to earlier, the Department of Labor can investigate the contractor, go back and make the agency include it, and at that point in time, you are on the hook, okay? And so that's the point in time where you would go back and ask for the price adjustment. If the SCA or DBA was never in the contract to begin with, that's where the changes clause would come into play. And you can get different costs under the changes clause than you can under the price adjustments clause. But if we're really just talking about a change in a wage determination, so the SCA or DBA always applied to my contract and now I just have an updated wage determination, then your costs and what you can get are more limited to what those price adjustment clauses require. Mm-hmm. Let's go to the next slide. How do you calculate these recoverable costs? We're always looking at this lovely thing I like to call the delta. And if you're math whizzes, you might remember the delta from math. So it's basically what the difference is, right? Like that's the short form of what the difference is. So under the price adjustments clause, your price adjustment is based on actual payments to employees, not based on the previous wage determination rates. So you have to look at, okay, what wage rate or what H&W rate am I actually paying employees? And then what's the difference between that and what the wage determination now requires? So in the example we have here at the last kind of paragraph of the slide, if a contractor is paying 10 cents more than the wage determination, so let's just say your wage determination rate is $20 an hour, you decide to pay $20.10 an hour. A new wage determination comes out and increases by 50 cents. So now the new wage determination is $20.50. You're only entitled to 40 cents, not 50 cents, because we decided to pay employees $20.10. So $20.50 minus $20.10 is 40 cents. Okay? And that's what you'd be entitled to per hour. You can also get associated taxes and things like that, and we'll talk about what that is in this slide. But it's your responsibility as a contractor, if you're a contractor, to request a price adjustment. So it doesn't come automatically to you, okay? The contracting officer has to modify the contract first, but then within 20 days or within 30 days of that modification, that incorporation, you should be submitting your price adjustment request. CBAs, you don't need to get anything back from the contracting officer for those to be effective. So you turn your, we'll have a few slides on collective bargaining too in a second, but you basically turn in that CBA and automatically that's your new wage determination once it's effective at the option. So you need to submit calculations and documents to support what you request. So you need payroll data. And often what you're looking at, say in the SCA context, say you have like a 20 or 30 cent difference in an hour, you're looking You look back at the last year to determine how many hours were worked, et cetera, et cetera. That's how you determine what your cost is going to be in the next year based on the difference. So if you had 40-cent an hour, let's take the example from the last slide. You had a 40-cent delta, and then you look back in the last 12 months and you say, okay, well, we did end up working about 2,000 hours per person and this many people, and you need to demonstrate that through payroll, what your deltas are, how many hours that were worked. If there are substantial differences between the last year and this year, you would look at, you'd have to justify that in your equitable adjustment request. So last year I only cleaned 15 buildings. This year in the modification I'm now cleaning 20. So I not only get last year's hours, but I get what I'm estimating for this year's hours. So that's generally how you're going to do it. This is really critical stuff to have organized and lay out really well so that we can simplify the process as much as possible, because it can be really, really complicated. For fringe benefits, we're really looking at the cost of your fringe benefits. And this can get pretty complicated because if you're providing health care, if you're providing retirement plans, life insurance, disability, we've got to justify those costs and say how, we have to justify the costs we currently have so we can show what we're currently paying. And that's how we show the delta, right? Because we've got to show what we're currently paying and why there's a delta. And so the more detail you can provide and the more organized that information is, and you can point the contracting office to it, the easier it is then to get your price adjustment. And we have a lot of questions. I know they're coming in. I'm not ignoring them, I promise. So hang in there with me. I promise I will get back to your questions in just a few minutes, okay? How do we calculate some of these recoverable costs? What can be included? Your adjustments can include obviously your labor costs, right? Plus changes in Social Security, unemployment, workers' compensation, okay? So you can take, most of those costs are a factor of the labor cost. And so obviously if your labor costs increase, then your Social Security, unemployment, workers' compensation are always going to increase. Increased costs due to fringe benefits such as vacation, holidays, and sick days are also could be included. Your adjustment request cannot include generally they cannot include G&A overhead or profit, so general administrative costs, overhead or profit, or costs which like travel expenses, uniforms, per diem. If you had a provision in a collective bargaining agreement that said, if you come back into work after you left for the day and I call you back, you'll get a minimum of 4 hours. They're not going to pay that. If you have anything associated with exempt employees, you remember those FLSA administrative executive professional exemptions? Well, exempt employees aren't service employees. So it's natural that the price adjustments clause won't apply to them because they're exempt. So you don't get any costs that you might decide to apply to exempt employees are not applicable during this clause. The one key thing that I think some contractors don't understand is the price adjustments clause is an either-or proposition. You can either, when you go out to bid for a contract, you can either bid in escalation in wage rates over the base plus 4 years or whatever the cost might be, or you get to take advantage of the price adjustments clause and basically flatline your wages and fringe and then take advantage of the price adjustments clause. You actually certify under the price adjustments clause that you have not escalated. It's almost like double dipping, right? Because if you've already escalated and you're already getting that escalation, then you can't also get whatever the wage determination said was an increase, right? So you kind of have to pick how you think it should work. We have a lot of questions about sick leave. So I wanted to just quickly talk about what sick leave is and how it applies, and then how price adjustments may or may not be applicable. So the sick leave executive order is 13706. The associated FAR clause is 52-222-62. And it basically said that employers have to provide employees working on a covered contract, which is essentially a Service Contract Act or Davis-Bacon Act contract, 1 hour of sick leave for every 30 hours worked on a contract, maximum of 56 hours per year. That does apply once it's in your contract to exempt employees as well as non-exempt employees, and anyone working in your home offices that work 20% or more of their time in connection with one of these contracts. And then they need to go into your CBAs as well. So that's the basic requirement for sick leave in and of itself. You might have noticed that if you're paying attention to wage determinations this year for SCA, the new wage determinations have a sick leave provision in them. And it says on the wage determination, essentially, if you have this FAR clause in your contract, you may be obligated to provide this sick leave to your employees. It also means that if you were an employer that was providing sick leave before and taking that sick leave out of the H&W rate, you can't do that anymore under this executive order. What you need to keep in mind is that the sick leave executive order applied for solicitations issued on or after January 1st of this year, of 2017. It may not be in your contract. Just because the wage determination gives you a reminder that the sick leave provision might apply to your contract, the wage determination is not requiring that you abide by this FAR clause, okay? So what you have to do is say, first of all, is that FAR clause in my contract? So go back and look, was this a solicitation issued on or after January 1st? And if so, do I have the FAR clause in my contract? If you have the FAR clause in your contract, then you decide what H&W rate would apply to you. So the new wage determinations have two H&W rates in them. They have a 441 rate and they have a 413 rate. The 441 rate applies if you do not have the sick leave FAR clause, that -62 clause in your contract. The only time you're eligible to pay the 413 an hour is if you do have it in your contract, because it's accounting for the fact that you have to pay for sick leave, right? And so the DOL took that into account when they did the new H&W rates. Again, this is a creature of contract. So you have to get your contract has to have the sick leave FAR clause in it, and it has to have the new wage determination in it, okay? You have to have both of those things. A lot of the questions I'm getting with respect to this one is, well, we got a contract that had the old 427 H&W rate in the wage determination, and we have the FAR clause in it. We have the -62 FAR clause in it. So it was early in the year that the contract was issued. So we were paying 427 and providing the 56 hours of sick leave, the 1 hour for every 30 hours worked. We get this new wage determination. It's incorporated into our contract. Now what do? Can I go back and pay the 413? You can pay the 413, but you're going to have to give the government some money back because you bid it with the 427 in it. So the price adjustments clause works both ways. It works when you get an increase and it works when you get a decrease. However, you are not required to reduce to the 413 level. You can stay at 427, provide the sick leave, and you're fine. And the Navy has a price adjustments guide, and it's not regulation, it's not rules, but it's a good way of thinking about the way the government thinks about these things. And it specifically says that you are not required to decrease, even if a wage determination decreases. So what you need to know is go back and look to see if that sick leave provision applies to your contract. And that's going to help you determine what H&W rate you should be at, whether it's the 441 or the 413 rate. The other thing I should mention is there should not be many price adjustments relating only to sick leave, because the idea is they went into new solicitations on or after January 1st of this year. So you would have seen that in the solicitation and you would have bid it the way that you needed to bid it for the base year. So you should not have many price adjustments just on account of the sick leave. Can a contracting officer include the sick leave in a modification? Yes, but it would be pursuant to the changes clause. It would be a change. Your contract would be modified to include the FAR provision, not the new wage determination, the FAR provision. And then you would say, okay, well, it's a change to our contract, and we should be eligible for all of the costs that are associated with a change in our contract. We wouldn't be limited to the same things we're limited to in the price adjustments clause.
We spoke a little bit about the application of unionized contractors in this world. And so this is just a little bit more reminders about what to think about when you have a CBA on your contract or when workers organize and start negotiating for a CBA. Timeliness is everything in this scenario. You want to make sure that you have a signed, ratified, and delivered to the contracting officer agreement at least 30 days prior to the start of performance. And that 30 days is really just what you want to keep in mind. Submit before 30 days of performance. And if you don't do that, there are some negative consequences, including that the CO might not accept the CBA and might not actually incorporate it into the contract. Because we said that it is automatically incorporated, but that's only if you get it timely submitted. And if you don't submit it on time, it doesn't mean that you don't have to abide by the CPA. You still have an agreement with your employees to pay them the certain wages and give them the certain fringe, but it doesn't mean that the government has to reimburse you for those costs. So it's really important that you get things in on time. Other things to remember are that you have to, the regulations require an arm's length negotiation. You can't just kind of come up with exorbitant rates and expect that the government will automatically accept those. It has to be bona fide negotiations. They cannot be at substantial variance with the previous wages. So if you have a $20 increase in wage rates, likelihood is that that's going to raise someone's eyebrows and they're going to come back and say, no, that's too much of a variance from the previous wage determination. You also want to remember that you can't have contingency clauses. For example, you can't have a clause that says this CBA rates only become effective if the contracting officer accepts them as incorporated in the contract. That's not okay. You also can't have clauses that say that if the wage determination, for example, outside of the CBA increases, then the CBA wages increases. Pretty much anything that says if in the wage and fringe benefits clauses, that's a contingency clause. You can't have that. Lastly, Nichole sort of touched on this earlier, but remember when you're negotiating these things that there are some things that are not reimbursable. Generally, wages, fringe benefits, bona fide fringe benefits are included. That's health and welfare, shift differentials, holiday pay, vacation. That does not include, however, things that are generally seen as benefits to the business, so uniforms or overtime is not going to be included, bonuses aren't included, paid meal breaks. So just because you have increased costs doesn't mean that the government's going to end up covering this ultimately.
Yeah, and there was a question about CBAs, and it's basically, do you have to wait for the increases to be modded into a new option year to include it into your monthly invoices? That is going to be very contract specific, but generally if it's timely submitted and accepted by the government, then yes, it's effective. But I would include it before invoicing for it. I would get a price adjustment request so that you can then invoice it. So you don't want to necessarily, I mean, you could work this out with the contracting office, but generally the way we see it is that you would submit a price adjustment first and then go ahead and bill it. The other question we got with respect to CBAs was if you negotiate higher wages in a CBA, you would make yourself eligible for a price adjustment. It's the same as with a wage determination. So it's the CBA just becomes a new wage determination for you.
I think there was another question about disagreeing with the CBA's wages being too high. It's hard to know exactly what the scenario is. If this is a new contractor bidding on a contract that happens to have a CBA, or if your own CBA wages have been too high. Ultimately, though, if the CBA has been accepted, that's the prevailing wage. That's the wage determination. When it originally gets submitted, as I mentioned, there could be that determination that it's too much at variance with the previous wage determination. But
and then the way that works is the contractor turns the CBA into the government. If the government thinks that there's an arm's length issue or a substantial variance issue, meaning the wages are too high for the locality, there's a process by which the agency has to submit that issue to the Department of Labor within a certain amount of time. And then Department of Labor actually makes that determination. And there might even be an administrative hearing. So a contracting officer can't just say, sorry, contractor, you're out of luck. There's a process that goes through DOL in order to make that determination. So the contracting office doesn't have ultimate authority over that. So I wanted to just do a couple of examples, and then we have about 15 minutes left, so we'll go through a couple of examples. And we would like your participation here just because I want to make sure, see who we still got. So ABC Contracting is awarded a contract with the Navy. The predecessor CBA includes a provision that requires severance pay to be paid to workers not hired by a future successor contractor. So you have a collective bargaining agreement and they say, okay, well, if somebody's not hired down the road, we want them to get severance pay. At the end of the option, the Navy determines to set aside the work for blind and disabled workers, triggering the CBA's severance clause for most of the workers. Would ABC be entitled to a price adjustment for the cost of the employee's severance? What do you guys think? And again, the same concepts can apply to regular wage determination, so there's nothing special about this. We'll give you guys a couple of seconds. Okay, we're going to close the poll in about 5 seconds. Looks like about half of you guys have voted, so love to see that a little bit higher.
We got it, 60%. Oh, they're still coming in.
Okay, we're going to close it down. The 46% of you that said yes are correct. So this is a hard one because it's like severance pay, really? Right. But yes, there are cases out there that say that severance pay is a bona fide fringe benefit that would be, you'd be able to capture that. But of course, you're not going to be able to capture it on the front end. It hasn't happened. So there are certain costs that maybe are hard to capture in a price adjustment within 30 days of modification of the contract. Severance would be one of those. But as long as it's been turned in on time and everything's going on the way it should be, if that provision was triggered, you could at that point in time go back to the government and request the price adjustment.
And the reason that it's a change to the contract is because essentially it's a change in price that the contractor would have been paying without the severance versus afterwards. And that's ultimately what you want to be considering. You're really just thinking about what is the increase in cost to me due to increased wages or fringe benefits.
Exactly. Okay. Let's go to the next example. A contractor classifies a bookkeeper as exempt. The DOL conducts an audit and determines that the employee should have been classified as non-exempt. So they paid the person a salary at first, and DOL comes in and says, nope, should be non-exempt, which means they should be SCA. The contractor has to pay thousands of dollars in back pay and fringe benefits. The DOL contacts the contractor about their failure to pay SCA wage rates. The contract makes no mention at all of the SCA or a wage determination. The contractor increases employee wages to the correct wage determination rate without waiting for the government to incorporate the wage determination into the contract. There's a couple of issues here, but what we're really trying to figure out is would the contractor be entitled to any sort of adjustment in their contract price as a result of this Department of Labor investigation? So would the contractor be entitled to any sort of adjustment or price adjustment as a result of this particular issue? Looks like we have about 50% of you voting. Almost to 60%. All right, again, we have another 5 seconds or so here. And okay, we're going to close it down. 27% of you said yes, 67% no, and 6% are not sure. And the correct answer is no, and for a couple of reasons. First of all, you'll notice that they had a classification issue here, right? So they had classified somebody as exempt versus non-exempt. So if it's a classification issue, unless the contract specifically said they have to be exempt or they have to be non-exempt, assuming it's like most contractors and most contracts and the contract just says classified people, then that would be one issue. The other issue was that they increased the employee wages in advance of the modification. So remember, DOL can come and investigate you, but ultimately if there's a problem like there is in this example where there was no SCA in there to begin with, then the DOL has to go to the agency first and get that fixed before they come after you. And once the agency does it, if you've done it in advance, remember the Delta rule, right? So if you've increased wages in advance, then you have a problem. And we see this issue all the time, where especially when new wage determinations come out in the summer and someone says, well, I just apply the new health and welfare rate, right? No. You've got to wait if you want the price adjustment, you've got to wait for the incorporation of that new wage determination into your contract. Okay, we're going to do one more example, and it's the same example in the first, but in this case, the contracting officer incorporated the correct wage determination into the contract. Then the contractor asks for a price adjustment. What costs would the contractor be eligible to recover? A is the difference in wages and fringe only. B is the difference in wages and fringe plus taxes. C is the difference in wages and fringe, taxes plus G&A overhead and profit, or none of the above. So keep in mind the last slide was essentially that the contracting officer had to go back and incorporate the entire SCA into the contract, not just the wage determination, but the entire SCA. Okay. This is a hard one, guys, but I have faith in you. I'm going to give it a few more seconds. About 60% voted now. I'm going to keep it at 5 more seconds. Okay. So we have about 26% of you saying A. I think the winner is B at the difference in wages and fringe plus taxes. C is 13%. That includes the G&A and overhead and profit. And 10% are none of the above. The answer is actually C here, and let me tell you why.
It was a trick question.
It's a trick question on purpose.
Don't be too hard on yourself.
So I told you earlier that if it's just a change in wage determination, the B's would have had it. If it was just a change in wage determination, we'd have to use the price adjustments clause, and the price adjustments clause only lets us get wages, fringe, taxes. In this example, you had a case where the SCA wasn't in your contract at all. And where the SCA or the DBA is not in your contract at all, then it's an entire change to your contract. There were a few cases that came out a couple of years ago that said, in a case where the SCA wasn't in your contract at all, you get to use the changes clause if you have one in your contract because you didn't have the opportunity to include the appropriate amount of G&A overhead and profit initially at the outset. And so you get kind of this one-time chance if they have to go back and incorporate the SCA into your contract. We see this all the time, so don't think it happens rarely. It happens very, very frequently. Now, going forward from option year to option year, you would be in the B group, only wages and fringes plus taxes, because the SCA would already be in your contract. The other thing I'd caution you about is certain contracts that require bilateral modifications, right? So there are certain contracts that require bilateral modification. In those cases, be careful, because you don't want to waive any rights to a price adjustment. So if you get a bilateral mod, make sure you have all of your money taken care of in that mod, or you have some way in that mod to request your money later, because you don't want to waive those particular issues. What are some common questions or pitfalls that we see? Well, the wrong WD, which we've talked about, right? What if I'm issued the wrong one? There's the wrong one in the contract. The wrong one gets in the contract. Remember, these are creatures of contract. So you can go back to the CO and help try to steer the course, but ultimately you follow what's in your wage determination, or you compromise your ability to get price adjustments. You could put yourself in a bad way with the Department of Labor. If your WD wasn't included in all in the contract, again, if you're at the solicitation phase, I would probably ask the question in Q&A, where's my wage determination? Look for references to WD numbers in solicitations or contracts, but if it's not in there at all, technically the SCA doesn't apply. And we've had those cases before where the SCA clause was checked, but there was no WD. You got to have both pieces. If a CBA doesn't have an effective date prior to the option year, so if you're turning a collective bargaining agreement, you want to be very careful that you have wages in effect in the prior year. So if you have a CBA situation and you're uncomfortable with this stuff, give us a call. We can talk through it with you. It doesn't take that long. If you pay, another issue is if you pay the new wage determination rate prior to modification, we talked about that, you could compromise your ability to get a price adjustment, because if you say raised, let's just take the new H&W rate of $441. If you raised everybody to $441 and then 2 months later you get a modification to your contract, what's the difference between $441 and $441? Zero. Remember, it's based on what you're actually paying employees. So don't do it early if you want to ensure that you can get that price adjustment. And we talked a little bit about escalation before. Make sure you classify employees correctly. That's critical. It's really hard to do. So exempt, non-exempt classifications, making sure people are in the right labor categories are really, really critical. And checking to see if you need a conformance, which basically is there's no category that applies to my people. I have to go ask DOL for one. And that's a whole process. And remember that overtime can be an issue as well. If you've misclassified somebody, chances are you could have overtime issues. So those are some of the big pitfalls that we see.
And these are some of the best practices that we kind of ask people to follow to avoid those pitfalls. You want to be careful to read your solicitation carefully. Notice if there's SCA clause, notice the types of positions, and pay attention. And if the SCA isn't in there, then don't pay the wage determination. You also want to make sure that you properly classify your workers and pick the labor classifications that apply to the wage determination. Remember, classification is on the contractor's responsibilities. You want to make sure that you pay the prevailing wage for the correct locality. These can be complicated. Make sure that if you're performing work in Sacramento, that you have the wage determination in Sacramento that you're looking at. And you want to never adjust wages before the wage determination has been incorporated. I think that that's maybe the overarching thing that we've hammered the most during this hour. Just make sure that you're paying what's in your contract. And if you're a prime, make sure that you're flowing down the SCA or DBA to your subcontractors, because you want to make sure that they're also conforming, because ultimately it's the prime contractor who's on the hook. So you want to make sure that the proper responsibilities are pushed down to subcontractors. And lastly, you want to make it as easy as possible for contracting officers to understand what you're asking for in a price adjustment. Include documentation, draft your request clearly and concisely, because you want to make sure that you have all the information there, but you also want to make sure that it's not overly convoluted or too long for anyone to really understand.
We have a ton of questions, and we apologize for not getting to all of them. We tried to get to as many as we could as we went through the hour. We will be in touch with you via email, so don't think we're ignoring your questions. We definitely see them, and we'll get back to you. But we appreciate your attendance today. We really enjoy doing these. We hope that you learned something, and feel free to reach out to us if you have any questions following this webinar. Hope everyone has a nice afternoon, and hope to talk to you soon.